What's up, YouTube? Haven't really been active on posting any videos, any updates here in a few days. So I figured I would go ahead and come live with this update. I'm over here at the United States Post Office. Hey, what's up, Double Ups? Seven Cities Kids. Thank you for tuning in. So I got this time I've actually got a pretty good update for you. First of all, I don't know how this is going to work out. I just had some more dental work done. The whole side of my face is completely numb. It's a little difficult to talk, but it's done. It's submitted. What I've got in my hand is a call come in. In fact, let me do this real quickly. No sense in letting calls interrupt this. Do not disturb. So this is my appellant's brief. This was what the Lafayette County Circuit Court has done has been nothing short of scandalous. Scandalous judges, just scandal, scandal, scandal. But it's Lafayette County, so what's new? I'm going to read some of this, depending on how fast it reads, maybe all of it. And I've got the link in the description for you to be able to actually read a copy of this brief. I would highly recommend that you go and do that. And another thing, I want to do a YouTube live stream or some kind of video teaching people the proper way to draft up a ironclad, bulletproof court filing. All right, so I got my table of contents right there. So I'm going to get into what this is about. All right, and you'll understand right here from the very beginning of it exactly what this appeal is for. I'm going to win it. This brief. There's really no defense for Attorney General Lynn Fitch's office. I just sent Attorney General Fitch her copy. I sent the court the copy, and I sent Judge John Kelly Luther his copy. So here's the statement of the issues. I've got 3 issues in this brief that I'm arguing on appeal at the Mississippi Appellate Courts. All right. First issue, whether the trial court erred by dismissing appellant's appeal based on alleged failure to file bond or cost despite an express judicial waiver of bond and cost due to indigency. Second issue is whether the trial and appellate courts violated appellant's constitutional right to continued appellate counsel, resulting in structural due process violations under the 6th and 14th Amendments. And the third issue is whether the cumulative errors amount to plain error, manifest injustice, and structural constitutional violations requiring reversal. The statement of assignment, this appeal does not involve issues that require assignment to the Mississippi Supreme Court. Pursuant to Mississippi Rules of Appellate Procedure, Rules 16B and D, the Court of Appeals properly retains jurisdiction. Statement regarding oral argument. I am requesting oral argument on this because the appellate court, the Court of Appeals, as well as the circuit court have epically failed in due process violations, constitutional rights violations, even at the appellate court level. So, appellant respectfully requests oral argument pursuant to Mississippi Rule of Appellate Procedure Rule 34B. This appeal involves critical constitutional issues, including the structural denial of appellate counsel, manifest injustice, and wrongful dismissal of an indigent appellant's perfected appeal. Oral argument would materially assist the court in understanding the factual and legal complexities surrounding these issues and in achieving a just result. The statement of the case. Appellant was charged and convicted in the Justice Court of Lafayette County, Mississippi. On December 2nd, 2021, the Justice Court entered an order finding appellant indigent and waiving all bond and cost requirements associated with his appeal. Let me just take a second to throw some shout outs real quickly. What's up, Rhett Watkins? Of course, Dub Wubs in Seven Cities said hey to y'all. Bigum Doley, welcome to the live stream. What's up, Richard? I always wear headphones. I mean, actually, I had the headphones on. I had some dental work done, and the headphones put me in my zone. And yeah, I was honestly, it's connected via Bluetooth, so I've got a microphone in these headphones. All right, so get back to it. Despite this binding waiver, once the appeal was lodged in the Circuit Court of Lafayette County, both the clerk's office and the trial court improperly demanded bond payment and costs from appellant in direct contradiction of the Justice Court's prior finding. To preserve his indigent status and seek appointment of appellate counsel, appellant filed an affidavit of poverty. While such an affidavit was unnecessary to perfect his appeal, given the standing waiver, it was filed out of an abundance of caution to facilitate a reappointment of appellate counsel pursuant to Mississippi Rules of Criminal Procedure Rules 6.2 and 6.3. Appellant timely filed his notice of appeal and continued to prosecute his appeal. Subsequently, appointed counsel filed a corrected notice of appeal and a motion to advance the case. Despite these efforts, the Circuit Court dismissed appellant's appeal on June 28, 2024, citing failure to post bond, even though bond had already been expressly waived. Additionally, appellant filed multiple motions seeking the appointment of appellate counsel. The trial court and the appellate court failed to act in accordance with the Mississippi Rules of Criminal Procedure, thereby denying appellant his right to continued representation. The record reveals that appellant was twice deprived of counsel at critical junctures. First, immediately after the Justice Court trial, the lower court terminated appellant's appointed counsel, Mitchell Driscoll, despite the pending appeal. Most critically, this termination occurred precisely during the 30-day window when appellant needed to perfect his appeal, the very period later contested by the Circuit Court as procedurally deficient. When the Circuit Court's dismissal order came on June 28, 2024, appellant was incarcerated at the Lafayette County Detention Center and had no access to his case, documents, or a law library. Without counsel to assist, appellant filed a pro se motion for reconsideration that, without access to the full record, missed the key legal argument about the indigency waiver. The Circuit Court judge made a troubling remark during the April 12, 2022 hearing, stating to appellant, "I would be lying if I told you I wanted your case, because I don't. Just being honest with you, you have a reputation of being difficult to deal with. And if I got half a chance to dodge you, I would dodge you like a speeding bullet." This was appellant's first substantive appearance before Judge John Kelly Luther, making the judge's negative characterization of appellant's reputation deeply concerning. Summary of the argument. The trial court's dismissal of appellant's appeal was legally erroneous because the Justice Court had found appellant indigent and waived all bond and cost requirements. This waiver was binding and should have been honored. The Circuit Court's failure to ensure continued representation of an indigent appellant on appeal violated Mississippi Rules of Criminal Procedure, Rules 6.2 and 6.3, and the 6th and 14th Amendments to the U.S. Constitution. The errors committed below, wrongful dismissal, denial of appellate counsel, and disregard of the judicial waiver of bond and cost, constitute plain error, manifest injustice, and structural due process violations. Reversal is mandatory. Argument. Letter A. The trial court's dismissal was in direct contradiction to the record and law. The Justice Court's indigency order eliminated any bond requirement. The Justice Court's December 2nd, 2021 order found appellant indigent and expressly waived all bond and cost requirements for his appeal. This waiver was binding and was acknowledged on the record by the Circuit Court during later proceedings. The cornerstone fact of this appeal, the Justice Court's waiver of all bond requirements, appears in black and white. This indigency order could not be clearer. Appellant is indigent and by reason of poverty cannot afford security required by law and is unable to give bond to appeal the judgment against him. Mr. Reardon is allowed to appeal if he desires to do so, and execution of judgment will be stayed without the requirement of supersedeas bond. This key fact is reflected in the record 3 additional times by appellant and his subsequently reappointed attorney. Even more troubling, this pertinent information was also raised 4 separate times by appellant in open court at the April 12, 2022 hearing. Most notably, Circuit Judge Luther himself acknowledged this fact on the record during the April 12, 2022 hearing, stating, on December the 2nd, Judge Childers says that you can appeal without a bond. Judge Luther reiterated this acknowledgement later in the hearing. Judge Childers has already addressed the issue of whether or not you can proceed without paying any money. Despite this, the Circuit Court dismissed appellant's appeal, citing failure to pay bond or cost. This dismissal directly contradicted the Justice Court's prior order and violated Mississippi Rules of Criminal Procedure, Rule 29.3 and 29.4, which govern bond and cost obligations for indigent appellants. In Jones v. State, the Mississippi Supreme Court held that a finding of indigency cannot be ignored without a proper hearing or finding to the contrary. Similarly, in Jefferson v. State, the court emphasized that procedural dismissals cannot override standing findings of indigency. The Mississippi Supreme Court has specifically reinforced this principle in Wallace v. State, establishing that once a defendant is determined indigent, courts must honor that determination throughout proceedings, absent evidence of changed circumstances. In Finley v. State, the court further reinforced that once indigency is established, courts must honor that determination, absent a clear showing of changed circumstances, stating indigency status carries with it fundamental rights that cannot be summarily dismissed through procedural technicalities. Here, there was no allegation, much less evidence, of any change in appellant's financial condition after the Justice Court's indigency finding. The Circuit Court's subsequent dismissal for failure to post bonds directly contradicts both the Justice Court's order and Judge Luther's own prior acknowledgement. This error is compounded by the fact that because the Justice Court waived all bond requirements, it never set any bond amount for the appeal, further confirming that no bonds were required to be posted. Under Mississippi Rules of Criminal Procedure 29.3 and 29.4, the responsibility to set an appeal bond rests with the lower court judge. The absence of any set bond amount in the record is not an oversight. It is the direct result of Judge Childers' explicit waiver. Thus, the dismissal of appellant's appeal constituted clear legal error. 2. Mississippi law protects indigent appellants from bond requirements. The protection of indigent defendants' right to appeal without financial barriers is deeply rooted in Mississippi law. The Mississippi Constitution, Article 3, Section 14, guarantees that all courts shall be open and that every person for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law, and right and justice shall be administered without sale, denial, or delay. This provision has been interpreted to mean that indigent defendants cannot be denied access to courts based on their inability to pay fees or costs. And this is very important, okay? Because studies show that approximately 80% of criminal defendants that go through the court system are indigent, okay? So what they're doing here is they're trying to set a precedent they're not going to set. They're just not going to set it, okay? Mississippi Code annotated 99-35-105 explicitly states that no person shall be deprived of his right to appeal because of his inability to pay cost. This statutory authority directly supports the binding nature of indigency determinations and the impropriety of dismissing appeals for failure to post bond when indigency has been established. The U.S. Supreme Court established in Griffin v. Illinois that states cannot condition appeals on ability to pay, holding that there can be no equal justice where the kind of trial a man gets depends on the amount of money he has. This principle was extended to misdemeanor cases in Mayor v. City of Chicago, where the court ruled that indigent defendants must be provided free transcripts for appeal, even for non-felony convictions, emphasizing that the distinction between felony and non-felony offenses drawn by the state bears no rational relationship to a defendant's need for a transcript. The Fifth Circuit is similarly held in National Association for the Advancement of Colored People versus Allen that the imposition of cost upon indigents as a condition precedent to access the courts is constitutionally impermissible. Furthermore, Mississippi Rules of Criminal Procedure, Rule 29.3b, specifically contemplates that indigent defendants may be excused from posting a cost bond, stating the cost bond may be waived for indigent defendants. Rule 29.4c similarly provides for waiver of the appearance bond for indigent defendants. The Justice Court's order fits squarely within these provisions, properly excusing appellant from posting either bond due to his indigence. Number 3, the Circuit Court's error constitutes plain error. The Circuit Court's dismissal of this appeal in the face of an explicit indigency waiver in the record constitutes plain error. In McGee v. State, the Supreme Court defined plain error as error that affects the defendant's substantive or fundamental rights. This standard is easily met here. The error is clear and obvious from the record, and it affected appellant's fundamental right to appeal his convictions. The error resulted in substantial prejudice by completely denying appellant access to a trial de novo on appeal. The U.S. Supreme Court has characterized plain error as error that is clear or obvious and affects the defendant's substantial rights. In most cases, for an error to affect substantial rights, it must be prejudicial and it must have affected the outcome of the court proceeding. See United States v. Default. The appellate court has discretion to correct plain error that seriously affects the fairness, integrity, or public reputation of judicial proceedings. For plain error to be reversible, it must also seriously affect the fairness, integrity, or public reputation of judicial proceedings. See United States v. Alano. The dismissal of an appeal based on a clearly erroneous ground, particularly when that error involves denying an indigent defendant access to courts, strikes at the heart of fairness and integrity in our judicial system. Allowing this dismissal to stand would undermine public confidence in the court's commitment to equal justice regardless of economic status. 4, procedural rules must yield to substantive due process rights. Mississippi Rule of Appellate Procedure Rule 2C expressly authorizes the suspension of procedural rules in the interest of expediting decision or for other good cause shown, particularly where a failure to do so would result in a manifest injustice. Federal due process guarantees similarly forbid denial of appellate review based on the arbitrary application of procedural hurdles where fundamental rights are at stake. In Eggleston v. State, the court emphasized that indigent appellants must be protected from technical dismissals that undermine their constitutional rights. The court held that once the determination of indigency has been made, the defendant does not have to repeatedly prove his indigency at various stages of the proceedings, meaning once it's approved at the beginning, it's approved. Hey, what's up, Gloria? Let's see. The Mississippi Supreme Court has consistently recognized that technical procedural requirements should not be enforced in a manner that defeats substantive justice. In Kennard v. State, the court reinstated an appeal that had been dismissed on technical grounds, reasoning that the defendant had not trifled with the court or acted in bad faith, and that allowing the appeal would not prejudice the state. Similarly, in Rowland v. State, the court held that procedural bars may be overcome where a fundamental constitutional right is implicated. The U.S. Supreme Court established in Johnson v. Mississippi that strict enforcement of procedural rules can never be permitted to supersede the enforcement of fundamental constitutional rights. That's important to know for anything, okay? Rules, policies, none of that trumps constitutional rights, period. End of story. Here, the appellant's conduct was diligent and in good faith at every turn. Any arguable technical misstep was either induced by the clerk's actions or promptly cured with the court's permission. The state would not be prejudiced by allowing this appeal to proceed, as it would simply have to prove its case in a fair forum, which is all that justice requires. The refusal to process appellant's filings, despite his established indigent status, further violated his due process rights under the Mississippi Constitution, Article 3, Section 26, and the 14th Amendment of the U.S. Constitution. B. The Circuit Court and Appellate Court failed to ensure continued appellate representation, violating fundamental due process in the Sixth Amendment. All right. Mississippi Rules of Criminal Procedure Rule 6.2 provides, this is probably, it's a toss-up between that, it's a for sure win on the first argument, but the second argument is very, very important, okay? Because what they tried to do is a snake move, okay? They tried to cut my defense attorney out and tried to leave me to navigate the waters of appealing. Luckily, I've got, some legal background, legal experience. God forbid I was somebody that had no legal experience. And that's why this issue is so important to me, because it's not that I actually need an attorney for this appeal in the Supreme Court, the Court of Appeals, because it's in the basket anyways, okay? But it's all about principle. Because if I was somebody that didn't know the law, I would be up the creek without a paddle. All right. So, Rule 6.2 provides defense counsel appointed by the court shall continue to represent the defendant through the appeal, unless relieved by the trial court or appellate court. Rule 6.3a further provides if the defendant is convicted, the court shall inform the defendant of the right to appeal and the right to appointed counsel on appeal if indigent. These rules apply to all criminal convictions, not just felonies. They impose a continuing duty on courts to ensure that indigent defendants have representation throughout the appellate process. Similarly, Mississippi Code 99-15-15 explicitly provides that for eligible indigent defendants. The accused shall have such representation available at every critical stage of the proceeding where a substantial right may be affected. The transition from trial to appeal is unquestionably such a critical stage. In Metcalf v. State, the court recognized that the right to counsel attaches at the accusatory stage and encompasses the defendant's right to have counsel through appeal. In Reed v. State, the court emphasized the importance of counsel during the transition from trial to appeal, noting that this period is precisely when defendants are more vulnerable to losing their appellate rights due to procedural technicalities. Further, in Williams v. State, the court reaffirmed that the right to appellate counsel extends through the first appeal of right. In Cockrell v. State, the Mississippi Supreme Court held that defense counsel's obligation to a client does not end with the judgment of conviction, and that counsel must take steps necessary to preserve the client's right to appeal, including filing the notice of appeal. Mississippi Rules of Criminal Procedure Rule 7.2c addresses the duration of appointment for indigent defendants' counsel, reflecting that expectation of ongoing representation. That rule generally provides that appointed counsel will not be permitted to withdraw before filing a notice of appeal. The purpose is to ensure that indigent defendants are not left without guidance at the crucial juncture of taking an appeal. When withdrawal is allowed, Mississippi Rules of Criminal Procedure Rule 7.3g requires that the trial or appellate court shall appoint new counsel for a defendant who is legally entitled to such representation on appeal. Despite appellant's timely motion seeking the appointment of appellate counsel, the trial and appellate courts failed to ensure appellant was represented. 2. The circuit court evaded its obligation by misapplying inapplicable felony standards. Rather than addressing appellant's October 17, 2024 motion for appointment of counsel on its merits, the circuit court improperly cited an unrelated, outdated order addressing a different motion. It incorrectly invoked Mississippi Code 99-40-1, paragraph 2, which applies only to indigent appeals division for felonies, while ignoring the broader mandates of Mississippi Rules of Criminal Procedure Rules 6.2 and 6.3. This procedural misapplication constitutes reversible error and a violation of appellant's due process rights. The circuit court effectively created an artificial distinction not present in the rules to justify denying appellant counsel at a critical stage when it was most needed. In Jones v. State, the Mississippi Supreme Court recognized that indigent defendants are entitled to counsel on appeal, regardless of the nature of the offense. An accused is not only entitled to counsel at trial, but he is entitled to counsel on appeal from a conviction on the merits. If he is indigent and unable to afford an attorney, then he is entitled to a court-appointed attorney at trial and on appeal. Thus, the court's refusal to appoint appellant counsel was legally erroneous. 3. The right to counsel extends through the appeal process. In Evans v. Lucy, the U.S. Supreme Court held that the promise of Douglas that a criminal defendant has a right to counsel on his first appeal would be a futile gesture unless it comprehended the right to effective assistance of counsel. Man, I love these little oranges. Mississippi Supreme Court has likewise recognized that an indigent defendant's right to counsel extends through the appeal of a conviction. Williams v. State. The U.S. Supreme Court has repeatedly held that a denial of counsel during the first appeal, which is what this is, as a right, constitutes structural constitutional error. Gideon v. Wainwright, the right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. Douglas v. California, Where the state is guaranteed an appeal, it must provide the defendant with the means of an effective appellate review, including appointment of counsel for indigents. Halbert versus Michigan. Navigating the appellate process without a lawyer's assistance is a perilous endeavor for a layperson and well beyond the competence of individuals who have little education, learning disabilities, and mental impairments. Flanagan versus United States. The right to counsel is among the basic fundamental rights that defendants must be afforded in criminal proceedings, and its deprivation cannot be fully remedied by a reversal of the conviction. The Fifth Circuit has also recognized the critical importance of counsel during the appeal perfection period in Hughes versus Booker, holding that the critical 30-day period after judgment during which a defendant must decide whether to appeal requires effective assistance of counsel. Similarly, in Peguero versus United States, the U.S. Supreme Court recognized that when counsel fails to file a requested appeal, a defendant is entitled to relief without showing that his appeal would likely have had merit. In Lombardo versus State, the Mississippi Court of Appeals specifically held that failure to appoint counsel for appeal constitutes fundamental constitutional error requiring reversal, noting that when an indigent defendant is denied his right to appointed counsel on appeal, prejudice is presumed. Additionally, Martinez versus Ryan, though focused on post-conviction proceedings, contains important language on the necessity of counsel during critical procedural transitions, observing that without counsel, a defendant is generally ill-equipped to understand and comply with procedural rules. Number 4, appellant was improperly deprived of counsel at critical stages. The record reveals that appellant was twice deprived of counsel at critical junctures. First, immediately after the Justice Court trial, the lower court terminated appellant's appointed counsel, Mitchell Driscoll, despite the pending appeal. Most critically, this termination occurred precisely during the 30-day window when appellant needed to perfect his appeal, the very period later contested by the circuit court as procedurally deficient. Although the circuit court later reappointed the same attorney, Mitchell Driscoll, in April of 2022, this reappointment came months after the critical appeal perfecting period had already elapsed. This timeline reveals the exact harm that Rules 6.2 and 6.3 were designed to prevent: an indigent defendant losing appeal rights due to lack of representation during the crucial period for filing procedurally correct appeal documents. The circuit court's eventual reappointment of counsel was essentially meaningless with respect to the appeal perfecting process, as the alleged procedural errors had already occurred during the period when appellant was forced to navigate the appeal process without any legal assistance. Had counsel's representation been continuous as required by law, the very issues later cited as grounds for dismissal would never have arisen. Second, when the circuit court dismissed the appeal on June 28, 2024, it allowed counsel to withdraw without appointing substitute counsel for post-dismissal proceedings and appeal to this court. Say hey to whoever's on here. Let's see, we got let's see, Oklahoma Outlaw. What's up, man? Gloria, good to see you as always, my friend. Excellent moderator right there. Excellent supporter. By the way, I know I announced that American Injustice would be released, would be published, was set for April 15th. Obviously, that's gotten pushed back just a little bit, running a little bit behind schedule, but I'll reiterate what I've said before. And Gloria, you've got one coming. Anybody that's a paid member of this channel, it could be any membership level. It could be the 99 cent, it could be the think it's a $2 one, $5 one. It could be any one of the membership levels. You will get a free audiobook of American Injustice from me. I haven't decided whether I'm going to sell the audiobook online for $15 or $20. Probably going to sell it for $15 online for the audiobook, giving the ebook out for free, and I'll be selling paperbacks as well. All right. So for those that I don't want not knowing who I am or not having the money to be a reason that you don't learn the truth. And the truth is what you're going to get with American Injustice. All right. So yeah, thank you all for tuning in. Those that are on here. Claire, what's up with you? What's up with the UK? All right. So denial of counsel at the first appeal stage is a structural constitutional violation. And Gideon, I think I've already read that. In United States versus Chronic, the Supreme Court established that prejudice is presumed when defendants are denied counsel at a critical stage, explaining that if counsel entirely fails to subject the prosecution's case to meaningful adversarial testing, then there has been a denial of Sixth Amendment rights that makes the adversary process itself presumptively unreliable. Similarly, in McCaskill versus Wiggins, the court emphasized that the right to counsel is among the most basic rights and that its denial affects the framework within which the trial proceeds. The 11th Circuit further explained why denial of counsel is structural in United States versus Roy, stating the right to counsel's guiding hand is so essential to our concept of a fair system that its denial at critical stages requires automatic reversal without any inquiry into prejudice. The Mississippi Court of Appeals has applied these principles in Ware versus State, explicitly recognizing that denial of counsel during critical stages constitutes structural error, requiring automatic reversal, because such errors affect the framework within which the trial proceeds, rather than simply an error in the trial process itself. The complete denial of appellate counsel is inherently prejudicial and mandates reversal. 6. Preemptive rebuttal to harmless error arguments. The state may attempt to argue that the denial of appellate counsel was harmless error. This argument fails. In Pinson versus Ohio, the United States Supreme Court categorically rejected harmless error analysis for complete denial of appellate counsel, stating the presumption of prejudice must extend to the complete denial of counsel during appellate proceedings. Similarly, in U.S. versus Default, holds that structural constitutional errors inherently affect substantial rights, explaining that for such errors, the appellate court has discretion to correct plain error that seriously affects the fairness, integrity, or public reputation of judicial proceedings. Thus, harmless error review is inapplicable. Reversal is mandatory. All right, C. Manifest injustice requires reversal. The extraordinary delay violates due process. Manifest injustice occurs when there is a fundamental denial of constitutional rights. In Rowland v. State, the Mississippi Supreme Court stated, manifest injustice occurs where there is a fundamental denial of a constitutional right. Similarly, in Keys v. State, recognize that errors fundamentally affecting the integrity of proceedings must be corrected, noting that the passage of time alone can prejudice a defendant's ability to mount an effective defense by dimming memories and loss of exculpatory evidence. Wrong color lights. In Weems v. State, the court established a clear test for manifest injustice, noting that it exists where the error has resulted in a denial of fundamental constitutional rights. The timeline of this case reveals an extraordinary and prejudicial delay. Justice Court trial and conviction, November 4th, 2021. Notice of appeal filed, December 3rd, 2021. Notice of appeal, circuit court hearing, acknowledging the waiver of bond, April 12th, 2022. No action by the court. The court fell asleep at the wheel. Somebody needed to wake Judge John Kelly Luther up behind the bench, and they didn't do it. But no action from the court, April 2022 to May of 2024, over 2 years. Dismissal of the appeal, June 28, 2024. Funny thing about that is I was extradited from Galveston on the sham setup. That was a conspiracy by Lafayette County right there, where deputies called over to Galveston. Beavers wanted to have me silenced. And I sat in jail in Galveston under suspicion of DWI for 11 months, and then they extradited me to Lafayette County, Mississippi. And literally 4 days after I got extradited back to Lafayette County, they toss out this appeal that had been sitting on the damn docket for 2.5 years. All right. By the time this appeal is decided, nearly 5 years may have elapsed since the original misdemeanor charges. Look, the original charge, many of y'all have seen where basically I got my ass whooped at the Lafayette County Sheriff's Office parking lot. I went up there to go try to speak to the sheriff after he ignored my emails. I was following the instructions of CPS because my daughter was being immorally held from me, and I mean it was direct violation of the order. It was during the time of COVID. So this was December 28, 2020. All right. These charges, or this that's going on appeal to the Supreme Court, to the Mississippi Court of Appeals, has to do with charges that were from 2020. All right. This delay is unconscionable, and it raises serious due process concerns. The Mississippi Supreme Court has recognized that excessive delays in criminal proceedings can amount to a denial of due process. In De La Beckwith v. State, the court applied the four-factor test established in Barker v. Wingo. Length of delay, reason for delay, defendant's assertion of rights, and prejudice resulting from delay. In Smith v. Huey, the Supreme Court identified 3 specific types of prejudice that can result from delay. 1, oppressive pretrial incarceration. 2, anxiety and concern of the accused. And 3, possibility that the accused defense will be impaired by dimming memories and loss of exculpatory evidence. The court specifically emphasized that the possibility that the accused defense will be impaired is the most serious form of prejudice, because the inability of a defendant to adequately prepare his case skews the fairness of the entire system. Similarly, in Dickey v. Florida, the court recognized that delay can impair a defendant's ability to defend himself due to loss of witnesses, the dulling of memory, and the dispersion of evidence, all of which are present in this case given its extraordinary age. Moreover, Kennard v. State and Sartain v. State demonstrate that appeals should not be dismissed absent bad faith or willful neglect, neither of which is present here. Here, all four Barker factors weigh heavily in appellant's favor. Length of delay, nearly 3 years passed between the filing of the appeal and its dismissal. An extraordinary time for a misdemeanor appeal. 2, reason for delay. The delay is attributable entirely to court inaction, not to appellant. 3, assertion of rights. Appellant consistently asserted his rights through motions and court appearances. 4, prejudice. The delay has caused substantial prejudice through faded memories, potential loss of evidence, and the ongoing cloud of conviction. Dismissal of an appeal perfected by an indigent appellant without any finding of changed circumstances or notice constitutes such injustice. Accordingly, manifest injustice demands reversal. The circuit court judge's bias further taints the proceedings. The record reveals disturbing evidence of potential judicial bias. At the April 12, 2022 hearing, Judge Luther made the following statement to appellant. I would be lying if I told you I wanted your case, because I don't. Just being honest with you. You have a reputation of being difficult to deal with. And if I got half a chance to dodge you, I would dodge you like a speeding bullet. This gratuitous comment raises significant concerns about the judge's impartiality. In Lichty v. United States, the Supreme Court recognized that judicial remarks that reveal such a high degree of favoritism or antagonism as to make fair judgment impossible can evidence bias requiring recusal. Judge Luther's statement, coupled with his subsequent dismissal on the grounds on the appeal on grounds directly contradicted by the record, suggests that impartiality may have been compromised. The U.S. Supreme Court further held in Aetna Life Insurance Company v. Lavoie that the Due Process Clause requires an unbiased judge and that actual bias need not be proven if the circumstances would offer a possible temptation to the average judge to lead him not to hold the balance nice, clear, and true. Cumulative impact, manifest injustice, and structural collapse. Even if individual errors were not sufficient alone, the cumulative impact mandates reversal. In Barker v. Wingo and Brown v. State, the courts recognized that cumulative constitutional errors require relief. The Mississippi Supreme Court has established that individual errors not reversible in themselves may combine with other errors to make up reversible error. Manning v. State. Here, the cumulative effect of the errors, wrongful dismissal despite waiver of bond requirements, and deprivation of counsel at critical stages, extraordinary delay, and evidence of potential bias has resulted in a fundamental breakdown of the judicial process that can only be characterized as manifest injustice. In Smith v. State, the court specifically recognized that when a combination of errors effectively denied the defendant a fundamentally fair trial, reversal is required, even if each error individually might be harmless. The repeated denial of appellant's rights, denial of appointed counsel, misapplication of standards, and outright dismissal of appeal collectively amount to a structural failure of due process. Appellant was stripped of meaningful access to the courts and was denied the opportunity for effective appellate review. In Brooks v. State, the Supreme Court emphasized that procedural bars must yield to prevent a fundamental miscarriage of justice. The constellation of errors in this case rises to that level. The deprivation of appellant's rights to appeal his convictions, combined with the denial of counsel and the extraordinary delay, has undermined the very integrity of the proceedings. The wrongful dismissal, denial of appellate counsel, and disregard of indigency protections combined to deprive the appellant of any meaningful opportunity for appellate review. Reversal is the only just outcome. Here's the conclusion and the relief that I'm asking. For the foregoing reasons, and upon the entire record, appellant respectfully submits the circuit court's dismissal of his appeal as erroneous as a matter of law and resulted in manifest injustice. The record irrefutably establishes that no appeal bonds were required due to the Justice Court's indigency determination. The denial of counsel at critical stages further violated appellant's statutory and constitutional rights. And the extraordinary delay combined with these errors has created a due process violation of constitutional magnitude. Given these exceptional circumstances, appellant respectfully requests that this court reverse the Circuit Court's June 28, 2024 order dismissing the appeal, and to render a judgment of acquittal as to the Justice Court's convictions underlying this appeal. The Mississippi Supreme Court has clear authority to render judgment rather than remand when justice does not require otherwise. Mississippi Rules of Appellate Procedure Rule 14b. In Smith v. State, the court exercised this authority to render judgment where procedural errors and delay had created substantial prejudice. Similarly, in Poole v. State, the court rendered judgment rather than remanding where the passage of time had made a fair retrial unlikely. Here, the nearly 5-year age of these misdemeanor charges, combined with the multiple due process violations, calls for this extraordinary remedy. At this juncture, remanding for a trial de novo would itself raise questions of fundamental fairness, given the age of the case and the prejudice already suffered. Alternatively, we might go cop watching. Alternatively, if the court declines to render judgment, appellant requests that the court reverse the dismissal and remand with instructions that the Circuit Court must honor the Justice Court's indigency determination, appoint counsel for appellant, and proceed with a de novo trial without further delay. Under Rules 2C of the Mississippi Rules of Appellate Procedure, this court is empowered to suspend procedural rules in the interest of expediting decision, or for other good cause shown, particularly where a failure to do so would result in manifest injustice. The exceptional circumstances of this case call for decisive action to prevent further injustice and restore appellant's fundamental rights. Appellant further requests all such other relief to which he may be entitled under law and equity. Respectfully submitted, this 29th day of April 2025. Matthew Reardon. Look, I don't care what they have to say in response. They're not getting around that. There's the system is beyond fucked if they can somehow wiggle their way out of that. There's just no hope for it. I could have a panel of the most incompetent judges, if there is such thing at the Mississippi Court of Appeals and Supreme Court. I could have a panel of the most incompetent judges that could see that through. All right, we're going to go down this way. And thank you all for sitting through that brief with me. I want to try to sure the trolls are on here. I'm going to read those comments in a little bit. I want to try to see if we can find what's going on over here. So I hope everybody had a good day today. I went back to the dentist again. Some more dental work. Novocaine is just now wearing off. It wasn't as bad as the last time. They shot me up with so much Novocaine the last time I went there a few weeks ago that I couldn't feel my right eyeball. Like my face was so numbed up. The amount that was over with. I wasn't feeling anything there. But they shot me up with so much Novocaine that I don't know, I couldn't feel my right eyeball. I'm not thinking we're gonna see anything down here. This doesn't look very enticing, very promising. All right, yeah, we're gonna turn around right here. Man, I love these freaking oranges. Yeah, y'all, thank you for hitting that like button. Those that hit the like button, please like this video and please subscribe to the channel if you haven't. I think I'm gonna one of the things I'm gonna do for future live streams. I didn't really want to do it because this is a new channel. It's still growing, and I'm not a fan of really, doing it for a new and growing channel. But I think I'm going to here in the near future. I'm going to set defaults on my channel to where whenever I go live or whenever I do a premiere, that you got to be a subscribed member of my channel to comment. One way or the other, I'm going to push those subscriptions up. So if the trolls want to get on there and say whatever they want to say, make themselves look stupid, they at least gotta subscribe to do it. And I don't mind trolls. Hopefully those that are on here that have been following what all is going on, I hope that y'all always outnumber them and can keep them suppressed. But if not, still hold my own. Oh man, I don't know where the hell I'm at. I went to this post office. Man, the mountains look beautiful. Let me show you this. So I don't know if you can see. Got my phone in its holder. That's about as far as it's willing to turn to the left. As soon as we get around these trees right here, look at these mountains. Still got a little snow on them. All right. Where? Well, at least we're out to somewhere that looks. It's not just deserted. It's inhabitable city streets. All right. Yeah, there's the mountains over there. Oh, is the volume fucking up? Here, let me do this. I should have probably known better than to record with that. Record with the headphones. So I've got the green screen right here. It's my mobile studio. Oh. All right. I need to find. disconnected. Give me a second, folks. Let me figure out where I'm at. Layton, Utah. Alright, I know where we're at. Yeah, so yeah, I haven't done much. I've been it's pretty unfair. I've been having to work around the clock on multiple court filings. I've got my lawsuit, that's the federal lawsuit against Layton, city of Layton and Oxford, Mississippi, and their police departments. That's I'm having to pull teeth on that lawsuit to get any type of traction with the damn judge. I had to rescind my consent to the jurisdiction. Basically, I had consented to a magistrate judge, handling matters, because a lot of times a magistrate judge isn't as busy as a district judge, and it can help matters get pushed through a little bit quicker. Well, the sole reason for me, consenting to that jurisdiction was to expedite the process. Well, I sent in two motions to lift the stay. Judge ignored it. I sent in a proffered declaration. Sent in invocation of my rights as a crime victim because of what happened. Ignored. So I finally said enough is enough, and I put in a motion to recuse that federal judge, and I withdrew my consent to the jurisdiction, and so now it's assigned to a district judge. Stay still hasn't been lifted yet. It certainly states very valid claims supported by declarations, affidavits, evidence. I'm not worried about any of that. I just want to know why it seems like the federal government is playing games. Okay, that's really what it comes down to. The federal government is playing games they shouldn't be playing. It started with the FBI. I took the sworn declaration trying to lodge, a federal investigation, federal charges against Oxford Police Captain Hilton Sessoms for his shenanigans with running the illegal interstate surveillance and then doxing my information across state lines, like a petty stalker with a badge. FBI wouldn't take it. They threatened me with arrest. Basically, if I didn't leave the parking lot, I've submitted OIG, Inspector General complaints that have gone completely ignored. They won't even assign a case number to it. I've left voicemails. The most recent thing is I've submitted 2 FOIA requests to the FBI. First one seeking anything that they've got on file dating back to 2017 on me. because that's important for what's going on. And the other one is when the FBI agent decided he was going to pull a cell phone out and record me through the window of the guard shack. I put in a FOIA with his picture, his face, and requesting the content off of his phone, the video that he took, as well as any correspondence that was sent or received from his cell phone that took the video. I'm 100% entitled to that. That's a, you know, anytime a public employee, a public officer, any, you know, public official, the second that they pull their cell phone out and they start recording you with their cell phone becomes public record that can be FOIA'd. And yeah, so the FBI is wanting to, they're not even acknowledging that I sent in two FOIA requests. So at this point, I can only assume, based on the fact that the Office of the Inspector General, which is out of the Department of Justice, is completely ignoring these major complaints that have been submitted to them. And based on the fact that the FBI is ignoring the FOIA request completely, acting like they just didn't get it, I can only assume that there was some type of like internal memo that had gone out in the Department of Justice to basically, you know, saying stonewall that guy. If you see any requests from him, ignore it. Just swat him away like a fly. I mean, how else should I look at it? The federal government's supposed to provide oversight over state, you know, like when the state freaking goes way off the freaking rails like they have. Who do you go to when the people you're supposed to go to are part of the problem? I mean, that's the $1 million question. Who do you go to when the people that you're supposed to go to stop something, for protection, when they're part of, when their complicity makes them part of the problem? And so now you got the hang up in federal court, and you know, I just don't, it's like a nightmare I can't wake up from. It's crazy. But American Injustice is coming out. It's right around 75,000 words. About 260 pages. That's 8.5 by 11. So that's not even shrunk down to book. So I need to get to work on recording that audiobook. That's really the hold up right now, is I need to get the audiobook. I need to get final proofreading done on everything, and then I'll have it out. But yeah, I'm gonna go ahead and end this live stream. I appreciate y'all riding along with me. I've got the link to that filing to the Supreme Court brief. I've got it in this description. Okay, I think it's rebrand.lee/Reardon-COA-brief. All right, check it out, because there is things in that brief. Obviously, not everything applies to you, or maybe none of it applies to you, but you'll find stuff that you can use at some point that can help you. That I am positive. But Hell. Yeah, I gotta get off here, y'all. It's hard enough navigating. Let me get off here. Y'all take care. I'm gonna check the comments out here in a little bit. I appreciate everybody that's gotten on here. I appreciate the trolls. I'm sure there's some trolls on here. Thank you for supporting the channel, and I'll be back with an update here soon. Take care.